Once again, I appreciate the panel for being here. And Mr. Kelly, ironically enough, I have a couple of property companies. We're in the process right now of trying to get about 20 acres platted, and it is absolutely absurd what we're having to go through. And the last time I had to go through, and the last time I actually purchased non-platted land, which is very scary, was 2007, I believe. And back then it was tough. Now, I don't even know if it's a chance to take. And so I do understand with what you're saying. I want to spend a little time with Mr. Strong. I think that's the first time I ever called you that. It's always been J.D. But hey, official titles, right? I want to spend a little bit more time with you on understanding a couple of things. One, I understand that you have been told, that your agency has been told that the rulemaking is going to be handled on a case-by-case situation. Is that accurate in saying that?
Yes, that is accurate. When we, of course, asked some of our regional district offices what the impact of this new rule would be on jurisdiction within our state, we were told essentially that it will continue to be, those types of decisions will continue to be made on a case-by-case basis, which sort of begs the question whether or not we're clarifying anything for anybody if every decision has to be made on a case-by-case basis.
So if you're already being told that, then the uncertainty that runs just in the state, not to mention by the time it trickles down to the farmers and to the home builders and to the other industries that depend on this. But when you're getting asked the questions, are you able to even make a decision now?
No, we're not. We absolutely are not. And you sure can't tell, I think, from reading the rule. Certainly the additional questions and answers from this hearing and follow-up calls that we're having now with the agencies are helping to clarify things. But I think, as Mr. Pfeiffer said, what's important is what's in writing. And so even though we may get some clarification outside the language of the rule through these types of forums, we need clarification in writing to give folks the finality that they need to be able to plan their businesses, their developments, and as a state to be able to implement these important programs to protect water quality in our states.
So once it's clarified, how much time are you going to need to be able to get your agency spun up to be able to even comply with the new rule that may or may not exist until you get a case-by-case clarification on it?
Well, I think if at the end of the day we got enough clarification in the rule that would support the statements made in the earlier panel that this really isn't any expansion of jurisdiction, then we would expect that it would have really sort of no additional impact on the burden on the states to implement the law. So really, it all sort of depends on what that clarification looks like. If it does, in fact, change the scope of jurisdiction in any way, then it would take us more than 90 days, I can guarantee you that, to figure out what the impact would be on the states and our programs to implement these Clean Water Act programs, as well as on our regulated communities.
Have you guys already identified some I guess what's the word I'm looking for here? Have you guys identified areas to where the state and the federal agencies are conflicting with each other?
Well, I think certainly you could easily read the rule as it stands right now and identify areas where what we thought before was totally subject to the state's jurisdiction could now be under the federal jurisdiction, which essentially removes the flexibility that was discussed earlier that's necessary for us to implement these programs in our states, in our various states, with our very unique hydrology that's vastly different from state to state.
I appreciate your time being here, J.D. It was always a pleasure to visit with you. Mr. Stallman, I want to go back to you real quick. With the Farm Bureau, the point I made earlier about existing farms, existing permits, have you guys had any clarification on this at all, such as what they're referring to?
No, not as was referred to by Mr. Perciasepi and Secretary Darcy. What we do know is it has been the position of the Corps and the EPA, based on a court case in 1987,
right.
U.S. versus Cumberland Farms of Connecticut, that unless from 1977 on you had maintained a continuous farming operation for which you had an exemption there under the
Right.
law that was passed by Congress, unless you maintain that continuously, you didn't qualify. That means there are no young farmers and ranchers that will be exempt.
So, and if you could, just a couple more seconds here. So the heartbeat of this country, being the farming community, in my opinion, is threatened here by seeing permits that are required to do some of the farming that we have to be less available or even non-existing. Are you hearing that from your members, or is that kind of assessment you guys are taking on your own?
More than they understand what the potential impact it could have on their farming operations, we are hearing that it will just not work. This law was never designed to regulate on a permitting basis agriculture.
Yes.
Our property is measured in acres, not in square feet.
Yes.
And the timelines involved in agriculture, the integration of what we do with whatever Mother Nature gives us, we don't have time to get the permits as the timelines are indicated it takes to get one, much less the cost of getting one. I'll be honest with you, if my farm is determined to need a permit to conduct my normal farming operations that have been conducted for over 100 years there's not enough profit margin for the cost of
Sure.
permits for me to make an economic decision to seek a permit and continue farming.
Thank you, panel, for being here. Thank you, Chairman.